श्रीमती अपराजिता सारंगी जी,
Mr. Chairman, sir, I thank you for this opportunity. It is indeed a privilege for me, as I stand in this august house, to speak in favor of Juvenile Justice, Care and Protection Bill 2021. I'm reminded of the wonderful words of Nelson Mandela. He had said, "There can be no keener revelation of a society's soul than the way in which it treats its children." समाज अपने बच्चों के प्रति किस तरह का व्यवहार करता है, इससे उस समाज की आत्मा की प्रकृति झलकती है. Juvenile Justice, Care and Protection of Children Act 2015 came into existence with effect from 15th of January 2016 by repealing the JJ Act 2000 with comprehensive provisions for two categories of children. First category, children in conflict with law. Second category, children in need of care and protection. Sir, we are aware of the fact that the JJ Act has been formulated in pursuance of the Constitution of India, which mandates equal rights for children and calls upon all the state governments to take appropriate measures for ensuring care, protection, safety, and security of children. Sir, if we go by the bill that has been placed before all of us today, we would find that this particular bill focuses on three major heads, which has been very clearly told to us by Honorable Minister, Women and Child Development. Number one, definition of serious offenses. Number two, adoption. And number three, functioning of child welfare committees. I offer my heartfelt compliments to Honorable Prime Minister Modi, Minister, Women and Child Development Department, and her team for responding sensitively to the needs on the ground which had emerged during the course of implementation of the JJ Act 2015. मैं तहे दिल से आदरणीय प्रधानमंत्री जी का, हमारी आदरणीय मंत्री का और उनकी टीम का धन्यवाद देना चाहती हूं. उनकी सकारात्मक सोच के लिए मैं आंतरिकता के साथ उनको धन्यवाद देना चाहती हूं. जमीन पर जो जरूरतें हैं, उन जरूरतों का अनुसंधान करना और फिर एक एक शब्द को पढ़कर सही पदक्षेप के लिए प्रस्ताव इस सदन में लाना काबिले तारीफ है. Now the question is, this particular act repealed JJ Act 2000. What was the need after 6 years to bring this here? In fact, I was listening very carefully to Honorable Minister. She was quite candid when she mentioned the reasons. At the cost of being repetitive, I would be informing the House regarding the course of events. This is a highly meticulous work of the ministry, and they deserve all compliments for whatever hard work that the minister and her entire team has put in. As per Section 109 of the JJ Act, the National Commission for Protection of Child Rights is mandated to monitor the implementation of the Act. Now, there was a case in the Supreme Court in 2007 in the matter exploitation of children in the orphanages of Tamil Nadu. Unfortunately, this particular case dragged for 10 years, and on 5th of May 2017, the final orders of the Supreme Court came. Now, as per the directions of the Supreme Court, the NCPCR had to conduct social audits in all these 7,900 odd child care institutions in the country. I'm extremely happy to inform the House, which I think is a repetition of what Honorable Minister said, around 7,163 childcare institutions underwent this social audit business. And unfortunately, sir, I would like to inform the House, not one childcare institution was found to be 100% compliant with the JJ Act 2015 provisions. All these childcare institutions are supposed to have written childcare policies. Hardly any of the childcare institutions had this kind of written childcare policy. This is one. Social audit is a great tool, and social audit is a great eye-opener. This is one reason, actually, the government, under the leadership of Prime Minister Modi, thought of correcting the things which were not correct on the ground in the interest of the children of our country. Now, sir, let me come to the second. In 2016, the Ministry of Women and Child Development, Government of India, set up a committee to look exhaustively into the way these childcare institutions were working. In 2017, the committee submitted its report. And unfortunately, damaging report. Very disturbing revelations again came. Now, sir, I would reiterate the fact that the Ministry of Women and Child Development, under the leadership of Prime Minister, was extremely meticulous for the right reason. We are talking about our children. And there are so many cases in front of us. In fact, I would like to mention here the case of Jalpaiguri Childcare Institution in West Bengal. It was a center of child trafficking for years together, and the State Commission for Protection of Child Rights would not listen. There was a case in the Supreme Court for that matter. The NCPCR would be writing to the State Commission for Protection of Child Rights in West Bengal. They did not pay a heed. And then ultimately, the ministry had to intervene, and the Supreme Court also passed very strict orders. Things were set right after the intervention of the ministry. This is what is happening in many of the childcare institutions. Now, sir, the third event in this line, why this, the rationale, the justification. The states and UTs sent a report to the ministry. I'm sure the ministry must have asked for the reports. Sent a report to the ministry. I have the date with me, and I have read the report. I have gone through the report in detail. It was 18th of September 2018. So, sir, we are talking of 2007 to 2017 Supreme Court case. We are talking of the committee report in 2017. The committee had been set up by the ministry in 2016. And again, we are talking of a report from all the states and union territories that were received by the ministry on 18th of September 2018. Amazing things came to light. In fact, the revelations were so disturbing that the Women and Child Development Ministry had to shut down 539 childcare institutions in the country because they were flouting the laws, because they were not conforming to the provisions of the JJ Act 2015, and all kinds of things that did not have to happen did happen in those childcare institutions, and that is why the ministry sprung into action. Now, sir, I come to the third portion of my deliberation. I request all the esteemed colleagues of mine to very carefully listen to whatever I have to say. And I'm extremely delighted to hear Madam Praneet Kaur. While she's sitting on the right-hand side, she supported the intervention of the government. This is what it should be. विकास कोई दल न देखे, दल मत निर्विशेष, हमें विकास के बारे में बातचीत करनी है और देश का विकास करना है. Number one, as far as the proposed changes are concerned, number one is definition of serious offenses. Now, there are three kinds of offenses that the JJ Act talks of: petty offenses, serious offenses, and heinous crimes, as we are aware of. Now, we should all agree to the fact that our children should be corrected, should be reformed, and should not be punished. You know, punishment actually doesn't correct the system. We want the children to be safe, to be sound, to be corrected, to be reformed. And that is why there was the need to change the definition of serious offenses. Serious offenses are those offenses for which the punishment as prescribed by IPC or any law in force is maximum imprisonment between 3 and 7 years, number one. Number two, the serious offenses as of now are cognizable in nature. That means a child can be arrested without a warrant, right? Now here there was a need to change this definition, and the definition of serious offenses was changed, has been proposed today to include crimes for which the punishments are maximum imprisonment for more than 7 years. However, minimum imprisonment has not been given, or maximum imprisonment beyond 7 years, but minimum imprisonment is between 3 and 7 years. This has been included. Now, this is also the definition of serious offenses. And number two, and very important, all these serious offenses have become non-cognizable. A child cannot be arrested now without a warrant. This is the proposal today before the House. Now, sir, as I mentioned, and Honorable Minister just said, I reiterate, we need to increase, rather widen the ambit of serious offenses. We need to bring down, or rather narrow, the ambit of heinous crimes. Our children need not be treated as adults. When they go to the heinous crime category, they would be treated as adults. We should bring them this side. We need to widen the ambit of juvenile justice system so that our children stay within that. This is the reason why this has been done, and this is one of the best measures that the ministry would have taken. Number two, I draw the attention of the House to sections 58 and 59 adoption. I'll not take much of time, sir. I'm trying to be as concise and as focused as possible, but I will definitely like to have time to elaborately tell you about what's good about this proposal. Sir, the Act lays down the procedure for adoption by parents both in India and abroad. Now, there is a specialized adoption agency currently which actually prepares a report. It's called a home study report of the prospective parents. And then on behalf of the parents, it goes to the civil court. Goes to the civil court and seeks the adoption order from the civil court. Now here, tremendous delay was taking place. We know how things are on the ground, sir. We are all people's representatives from different parts of the country. We know how things are. So this situation on the ground was studied by the government, by the ministry. And now the proposal is the adoption order will be certified and issued by the district magistrate, and this district magistrate will include the additional district magistrate. I have lots of regards for Madam Praneet Kaur. So very well, in such kind words, she supported the intervention of the government. However, she has some, I would say, apprehension regarding the DM not being able to give time to this aspect of work because he or she is burdened. I fully appreciate that, sir. With all humility, I would say that I was serving as such in a couple of districts in Orissa, my cadre. But at the same time, let me tell you, sir, with all humility, that the DM is the only person who is the chief coordinating center in a district. And when these things are done, lots of coordination is required among various agencies, among various stakeholders. You know, implementing things require a leader. And in a district, only the collector can be a leader, a collector or a DM who can actually collaborate and coordinate with everybody. And that is why it's very important to have the importance, or rather the responsibility given to the district magistrate, which includes the additional district magistrate as per the bill which has been submitted before us. Now, the third and very important thing is functioning of the Child Welfare Committee. So I draw your attention to Section 27, Clause 8, Section 40, Section 2, Clause 26 of the Juvenile Justice Care and Protection of Children Bill 2021. What's the situation right now? The district magistrate is supposed to review on quarterly basis the working of the CWC. There is a DCPU, the District Child Protection Unit, which will be the focal point to ensure the implementation of the act. This is what it is as of now. But this is all nebulous. This never happens. Now, sir, now there is some kind of force, some kind of emphasis, and some kind of clarity. We need candidness, we need clarity when we have to deal with such sensitive issues as the care and protection of children. Now, sir, it has been proposed in the bill that the CWCs shall submit a report on quarterly basis to the district magistrate. It will also submit a report on quarterly basis to the state government and the district collector about what? About the disease, the restored and runaway children. This is path-breaking. This was not there earlier. This has been brought in, and extremely important. The DCPU, the Child Care Protection Unit, would be headed by the collector. It would work under the direct supervision of the district collector. So I think much of the nuisance will go away, sir. As I told you, I reiterate, I can say with all conviction at my command that the district collector is the chief force in the district. He or she is the coordinating point, and he or she can be the focal point, and this is a very good decision on part of the government. Now, sir, the last proposed change. Many of us, my learned, esteemed colleagues here in the Lok Sabha, must have gone through the book Good to Great by Jim Collins. This is one of the best management books I think many of us have read. In this book, one of the management techniques which Jim Collins talks of is put the right people on the bus. Unless and until we have the right people in the bus, we will not be able to achieve the goal. So it's very important to have the right people as members of the Child Welfare Committee. A Child Welfare Committee has a chairperson and 4 members. Now, sir, there are certain things which cannot be compromised. Whatever, come what may, we cannot compromise with the quality of the people that we induct in here. So, sir, educational qualification, fine. 7 years experience, fine. But here we are saying educational qualification plus 7 years experience in the field of dealing with children's issues, and one more thing which has been added. Specially abled children, or rather we call them differently abled children. The member should be having, or rather one of the criteria is he or she should be having some kind of qualification pertaining to the handling of differently abled children. This has been added, sir. This is extremely important. Now, sir, what attracted me to this qualification criteria was the disqualification criteria which has been added, and I would like to read those. Anybody who has drafted this must be complimented. Sir, the bill considers the following qualities as disqualifying criteria. This was never there. We always said this is the qualification criteria, take this person or take that person. But here we are also talking of disqualifying criteria. There is absolutely no compromise because children are involved. Sir, what are the disqualifying criteria? 1, past record of human rights or child rights violation, the person will be thrown out. Number 2, conviction in an offense involving moral turpitude which has not been overturned by a subsequent judgment. History of being removed or dismissed from any service of the government, whether central or state. Improvement in child abuse or child labor. Last, a person who is currently a part of the management of a child care institution in a district. So, sir, these are the disqualifying criteria which have been added to the bill. Now, sir, we are very proud of the fact that we have plethora of laws, schemes, rules, regulations. But I think the important thing is whether we are able to implement them to the satisfaction of all, and we are able to achieve the expected outcome. Now, if we are able to bring in all these amendments, if we are able to implement this particular JJ Act with amendments today which has been brought in, very carefully, with all sincerity, with due diligence, and with a heart and a good mind, I think we would be able to achieve the expected outcome. Sir, I would like to conclude with 3 lines. Please allow me. Good, better, best. Never let it rest till your good is better and your better best. Prime Minister Modi and his team have been trying very hard to move from good to better and better to best. Now, this is an opportunity. We need to move from better to best. From 2015 to 2021, we are trying to move to the best. And I request each one of my esteemed colleagues present here to wholeheartedly support the bill which has been brought today, just because it is in the interest of our children. Thank you so much.
Thank you very much.
Please like, share and subscribe to our channel, and your comments are valuable as well.